Thank you, counsel.
Haven't, though, General, we been pretty generous in terms of what we call functionally a statute of limitations? I mean, take the Beckler case that you ended on, which was just an appeals deadline. You know, I bet if you put 10 lawyers in a room and said, is an appeals deadline a statute of limitations, they would kind of stare at you funny. You know, what it is, it's a deadline. I mean, a statute of limitations is also a deadline, but we don't typically think of every deadline like an appeals deadline as a statute of limitations. But we've been willing to call it that just because it's a deadline, and if you don't meet the deadline, consequential things matter. Consequential things happen. And so too here. This is a deadline, and if you don't meet the deadline, consequential things happen. Now, in this case, it's the loss of a forum rather than the loss of a claim. But I guess when we're being quite as generous and quite as functional, if you will, as we have been in this area, it doesn't seem to me obvious why we shouldn't say that this isn't functionally a statute of limitations too.
It's very different because although there might be consequences and there might be a right involved, the court in Young said it had to be a substantive right, and it defines a subset of claims eligible for certain remedies. And here, when you're talking, it's all about remedy and whether you're going to lose the remedy. And the reason statute of limitations doesn't apply here is because there isn't a harsh consequence. The reason statutes of limitation apply to cases is because, and why there's equitable tolling is because there are very harsh consequences. Somebody's going to lose out completely on their ability to bring a case. That's not true here. They're going to get one forum or another, and maybe they're not going to get their preferred forum, but they're going to get a forum to litigate their case. And that's the biggest thing that separates this from a statute of limitations. And this court has never applied statute of limitations beyond the presumption of equitable tolling beyond statute of limitations, and I think that's one of the reasons why. And if the court was thinking of expanding that at all, it wouldn't be here, it shouldn't be here, where there's a whole distinct tradition of strict enforcement. We cite cases on pages 50 to 51 of our briefs, starting from Babbitt versus Clark in 1880 onward, where this court has strictly enforced the deadline. And there's a reason for that.
Counsel, can I ask you about that?